Good morning, everyone, and a warm welcome to our webinar, Testing and Certifying for Exports, Benefits of Mutual Recognition Agreements on Conformity Assessment Content. This is the second webinar of the Embracing Global Markets webinar series, which is hosted by Enterprise Europe Network and experts from various European Commission services to support SMEs and startups expand globally. I'm Erika Mara Garcia, and I work as a policy officer at the European Commission's DG GROW in the Enterprise Europe Network team. Today, we're delving into mutual recognition agreements that are important instruments that facilitate market access abroad by reducing certification and testing barriers for products. We'll be exploring the vast opportunities these agreements offer to EU exporters, particularly with countries such as the US, Canada, Australia, New Zealand, Japan, Israel, and Switzerland. Joining us today are esteemed colleagues who will bring invaluable insights. We have Katia Modric Skrabalo, who is a policy officer at the Commission's Directorate General for Trade. Welcome, Katia. She's a member of the Regulatory Cooperation and Public Procurement Unit. A big thanks goes to her for the preparation of this webinar and for sharing her knowledge on MRAs with us today. We also have with us Agnieszka Turinska, who will be closing the webinar and moderating with me. Agnieszka is Senior Project Manager at the Wrocław Technology Transfer Center, and she coordinates Enterprise Europe Network in West Poland and is also chair of our EN Internationalization Working Group, who is also behind the organization of this webinar series. I would conclude with a few words on the housekeeping rules from my side. Throughout the webinar, we encourage active engagement, especially as it's a technical topic. So for this, would you have any question to raise, depending on the portal you're following from? You can write them on the WebEx chat or in the YouTube live chat. Agnieszka and I will be raising your questions to Katia as you write them down to make this session interactive. In alternative, you're also invited to raise your hand here in WebEx for live questions, and Agnieszka will give you the word. Please be aware that the webinar is being recorded in WebEx and via the live stream. The recording will be then provided shortly hereafter on the YouTube channel and in our internal Learn portal. With that, let's dive into our webinar. Katia, thanks again for your precious presence with us today. I leave you the floor.
Thank you very much, Eric. Thank you again, and thank you everyone for attending this webinar. I am grateful for the opportunity to present to you the mutual recognition agreements and the role that they play in international trade. I have prepared a presentation that I will share with you in a moment. I hope you see the presentation now.
Yes.
Thank you. So yes, I work as a policy officer in the Commission, in the Director General for Trade, and in the unit that is called Regulatory Cooperation and Public Procurement. So it's the title of the unit, it's a bit cryptic, and it doesn't mention actually the main job that I am responsible for, which is technical barriers to trade and addressing these barriers with our trading partners, also through mutual recognition agreement, which is part of my responsibilities. So today, I will talk to you about these agreements, and you might ask yourself what are they and what is their role and how do they facilitate trade. And I hope that by the end of the webinar, you will understand better their role and that you will maybe think about how to use these opportunities that exist in your future export activities. Nowadays, trade flows are not subject to very high tariff as it used to be a time ago. but the non-tariff rules and regulations have proliferated in the last years, and they play a very important role in hindering trade. So we try to find a solution to lower these barriers, because while on one hand they do play an important role to address the public policy objectives, which are in most cases the protection of health and safety of the citizens of a country, or the protection of the environment. On the other hand, they do act as a barrier to trade, and the companies that are engaged in global supply chains, they need to comply with the whole range of administrative but also technical requirements with which their products have to comply in order to be placed on the market in those countries. Some of the elements of these requirements are also represented in the testing and certifications obligations that the manufacturers have to fulfill, and which testing and certifications represent an additional cost for manufacturers or exporters. So there have been several studies that addressed the non-tariff measures. The most recent one in 2016, it was a very large survey of 8,000 European businesses, looking into non-tariff measures, and non-tariff measures can be various administrative or technical requirements. Subset of these are the so-called technical barriers to trade, or technical requirements. So technical requirements are requirements that are set in laws and regulations of third countries or any country, and which set out mandatory product characteristics or their related processes and production methods. In addition to these mandatory technical requirements, there are usually also the mandatory procedures for the assessment of conformity of products with these mandatory technical requirements. And these procedures for the assessment of conformity, we call them conformity assessment procedures, or CAPs. They are often requiring the certification or testing by third party, which can be a laboratory or a certification body. So now, third party, this means somebody outside of the manufacturer. So it is not sufficient that the manufacturer states that the product complies with the technical requirements. In addition to that, the manufacturer has to submit its product to another company, which is a certification body or a testing laboratory, which will then perform these so-called conformity assessment procedures. And the survey from 2016, which was a very large survey, actually found out that these conformity assessment procedure represent 30% of all non-tariff measures that the European manufacturers have identified as being burdensome. So
Katja, sorry to interrupt you, but your slides are not changing.
No, I didn't move. I didn't
okay,
move the
okay,
slide
okay.
yet, because
Yes,
I wanted
okay.
to have the attention of the speakers at least for a first couple of minutes.
Okay, okay. Sorry to interrupt.
Yes, there will be more. This is more of an introduction. So these 30% of barriers that are embedded in that are related to conformity assessment procedures, this shows how important the conformity assessment procedures are, and how important actually the mutual recognition agreements are, because they try to address exactly this specific part of the barriers of non-tariff measures that are encountered by the manufacturers and the exporters. And the mutual recognition agreement is only one possible instrument that is aimed at facilitating market access and promoting trade between the parties through the mutual acceptance and recognition of these test reports and certificates confirming conformity of products with the mandatory technical requirements that are set in legislation. We can all agree that each economy or each country has the right to set the levels of health and safety as it deems appropriate to protect its citizens and consumers or the environment. However, these protections have to be applied in a non-discriminatory measure, in a non-discriminatory way vis-à-vis imported products. And nonetheless, the fact that you have to access another country market already requires the exporter to learn about these technical requirements. So there is an information gap that they have to fill and learn about mandatory product requirements in order to be able to export the products. The mutual recognition agreements in general, in their traditional form, they do not address technical product requirements that are embedded in laws and regulations, nor they do address standards that may be differing from country to country. The mutual recognition agreements address the specific part of barriers which are embedded in the results of conformity assessment. And when there is a mutual recognition agreement in place, then the countries accept among themselves the results of the mandatory conformity assessment procedures that have been carried out in one party, in the exporting party, so that the product can be imported to the other country with this same certificate, which certificate conforms that the product complies with the importing party requirements. There have been some studies of the economic impacts of the MRA throughout the years. The EU has concluded its MRAs in the late 90s, and similarly other countries as well. And so the studies are from the early 2000s. On this slide, you can see that not only the value of the currently exported product will increase in the presence of a mutual recognition agreement. There is also the increase of a probability that some new products will be exported to some new markets. So there is quite robust, I would say, evidence that MRAs are a useful tool for trade facilitation. There is a very let's say renewed interest in the MRA now, in the MRAs currently, because the countries tend to regulate more and more new risks related to cyber security, or let's say digital products or digital aspects of products, as well as products which are related to the transition to the green economy. And as these new regulations are emerging, the question arises, could we lower the trade costs of these new regulations by expanding our current MRAs to also new areas such as those covered by the digital and twin transition. So one other element or objective of this webinar is to inquire or to raise awareness of the potentials of the MRAs for new product sectors to be included in the current agreements. Now, this being said, about the benefits of the MRAs, we have to also stress that not every trading partner will be a good, let's say, candidate for an MRA, and also not every sector will be a good sector that would be a candidate for an MRA. One, let's say, underlying factor which would we need to be fulfilled in order to start to negotiate MRAs would be the fact that there is mutual trust between the regulators that are concluding the agreement, so between the partner country. This means that the partner countries need to have a similar level of development of the quality infrastructure, and that they need also to have a similar approach to health and safety or other legitimate interests that they want to protect vis-a-vis their citizens. Then the requirements or the regulations need to be similar. I mean, both economies need to have regulations in place for a specific sector or for specific risks or specific aspects of products. Then there needs to be, at least at one side, a mandatory conformity assessment procedures that is prescribed by the regulation. And finally, we also need to have, like both economies need to have a similar way in which they assess how these conformity assessment bodies, which are usually private bodies, how these bodies check upon conformity of products. What are the requirements for these bodies? How do we assess the technical competence of this body to do their work properly, and so that we are able to trust the certificates that these bodies have issued? And in the EU, we rely a lot more mainly on accreditation. So there is accreditation in each member state of the EU, and there is an accreditation body which provides a public, which has a public authority to provide this accreditation service to conformity assessment bodies. So through the accreditation, the technical competence of the conformity assessment bodies is assessed and ensured. And on the basis of that accreditation, then the conformity assessment bodies are designated to become a third-party body that do these and issue certificates that have a legal value in the country, in the system. In the EU, we generally use third-party conformity assessment only for high risk products or medium to high risk products, such as medical devices of a second, third class, or lifts or cableways and similar, or high risk machinery. But for many other product sectors in the EU, it is sufficient to have just the supplier's declaration of conformity, meaning that the manufacturer can issue such a declaration on his sole responsibility. And in this declaration, the manufacturer will state that the product complies with the mandatory technical requirements. On the contrary, in many third countries, we are faced with mandatory conformity assessment procedures also for products of low risks. And this is why we are trying to address this, let's say, this balance in regulations through our free trade agreements negotiations, where we promote the use of suppliers' declaration of conformity, and we ask countries to conduct an impact assessment and to look into ways to facilitate conformity assessment through suppliers' declaration of conformity in cases of low to medium risk products. Nonetheless, there will be sectors and areas where there is third-party mandatory conformity assessment use, and in these areas, the MRAs will come into play. On this slide, you can see how does the MRA work in general. So the MRA provides for the possibility of the exporting party to designate a conformity assessment body under the provisions of the agreement to the importing party. The importing party will have to accept this designation of a CAB. So the importing party will have the possibility to ask questions or to require the submission or of additional documentation in order to accept or to ensure that the conformity assessment body of, let's say, the exporting country fulfills the necessary or has the necessary technical competence to do conformity assessment. So this part is more on the regulator side. This is not something on which necessarily the manufacturers or the suppliers are interested in. They might be interested because they might be using in Europe a conformity assessment body, which body is not a designated CAB under an MRA. So they might kind of suggest or see or whether their own CAB would be interested to become designated under the MRA. Anyway, once the conformity assessment body is designated, the supplier, the manufacturer, will be able to use this CAB to assess its products against the requirements of the importing party. This means that the manufacturer will be able to use its own CAB. So there may be the case that that he's already operating with a company or CAB of trust, and he will just expand on certain tests and certificates in order to be able to then sell the products in another economy. This will save money to the suppliers because they will maybe also use some of the test reports that have been used for the EU. They will be able to use them also for the importing for the export of their products. In addition, they will save a lot of time as well, because they will not have to send their products to the importing country to be submitted to the testing and certification. So they will save time, they will save money, and they will also save themselves of certain administration, which is linked to submitting to the third country conformity assessment bodies. And the result of that will be that the certificates that are issued in the EU and that certify that the product complies with the requirements of the country in which the product is intended to be exported will be recognized by that country. As I mentioned already earlier, this doesn't presuppose any equivalence of the technical requirements per se, nor the recognition of the standards, either national or international. I would like to stop at this point and to see whether there are any questions from the audience.
No questions in the chat so far.
Maybe somebody would like to ask a question already at this stage, so please raise your hand and we'll give you the possibility to do so.
Hi, Maxime. Would you like to send? Yes, the session is only about the countries that have an MRA with the EU. Okay.
Thank you, Katya.
Yes.
And I just said thank you because I just joined this. I signed up for this session like 10 minutes before because I was dealing with another problem on C certification, but not related to MRA countries. So I just joined it now just to see if this could help give me some guidance, but no.
Maybe yes, but we are talking about other, let's say, international schemes at the end. I'm just briefly mentioning them. So
Okay.
there is also something about that at the end of the presentation as like alternative ways to the MRAs.
Great, thank you.
And Maxime was asking something about mutual trust. Yes, I made reference to mutual trust, and that was vis-a-vis the trading partners with whom we would enter into negotiations. So the EU would look into the level of development of the quality infrastructure in that third country, and only with countries where there is a similar level of quality infrastructure development and a similar, let's say, approach to the protection of health and safety of citizens or other legitimate interests that would be for sectors that would be in the scope of the MRA, there would be then sufficient mutual trust to enter into such negotiations of an MRA. And this is because the EU, so now I'm talking about the EU, but it works the other way around as well. So each party, let's say in this case, the EU needs to have a sufficient level of trust that the conformity assessment bodies that have been designated by the partner country are competent to do their tasks, and that in case of issues that might, let's say, surface vis-a-vis the competence or vis-a-vis the certificates itself, that the EU can get in touch with the partner country authority, and that authority is able to address these issues with its conformity assessment bodies that it has designated. So for that reason, there is an element of administrative cooperation between authority that follows or that goes throughout the implementation period of the MRA. So it's not only linked to the moment of the designation of the conformity assessment body, but there needs to be regulatory cooperation between the trading partners throughout the implementation to ensure that the certificates can be trusted upon and relied upon by the authorities of the trading partners. So if there are no more questions for the time being.
Yes, Katya, I would like just to remember to those following on YouTube that they can write down their questions in the chat and we will read them if anyone has joined later. Thanks.
Thank you. Thank you very much.
Katya, hi. I also have a question. I'm sorry for my ignorance, but I assume that these bodies, designated bodies, have to know very well what are the technical requirements of the parting of each parting country,
Indeed.
right? And
Indeed.
is there, I mean, the body, the certified body, is it one body for all for all the trading partners, or it depends which trading partner we are, dealing with?
Talking about.
Yeah.
Yes, thank you for this question. Excellent question, actually. So indeed, the conformity assessment bodies need to invest in learning the requirements, and that is one element where the manufacturers then save, because somebody has learned for them. And this is especially important for SMEs, because then if these CABs know, they can provide necessary information to the SMEs. What are the third country requirements? But indeed, in order to be able to certify the product, the CAB has to invest in the knowledge of that specific sector and the regulations of the country for which it is certifying. So usually the conformity assessment body tends to specialize in some countries. And they also specialize in sectors. So there are very few conformity assessment bodies that have a very broad expertise. There are these big players that you have probably heard about, the TÜV, the SGS, the UL. These are the big conformity assessment bodies, and they cover the globe. So they usually have subsidiaries in many countries in the world, and they are able to, let's say, service any manufacturer. On the other hand, in the EU, we cherish SMEs, and we cherish also SMEs in the area of conformity assessment. So in every member state, you will find at least one conformity assessment body for a specific sector. Sure, there are big players as well, but there are also small players, and they usually they provide the service for the suppliers in their own country mainly, but they also tend to expand to other member states because the conformity assessment bodies in the EU, they are competing among themselves. So you will find a manufacturer in Italy using a conformity assessment body from Croatia or Slovenia because of proximity and then looking into price, they might bring some savings. That might be the case. So the MRAs tend to benefit not only small manufacturers who are interested to export, they also tend to provide some, let's say, opportunities for conformity assessment bodies.
Thank you.
Okay, if there are, I don't see the chat, so I trust there are no more questions. And
There are no more questions, Katja. You can
okay,
move.
good. Thank you. Good. So I will move to the next slide. So we have talked until now about these traditional MRAs. I have a slide also on enhanced MRAs, and we have only two of them with two countries when it comes to general industrial products, with Switzerland and with the US. With Switzerland, we have the MRA that covers a broad range of sectors you will see in a later slide. But what is the difference between these enhanced MRAs and compared to the traditional MRAs? The enhanced MRAs have an added value which lies in the fact that in addition to the recognition of certificates, which stays, here also the regulations of the partner country, of the two partner countries or economies, are equivalent, or they are the same. So this means that a product that a manufacturer is able to place on its own market, let's say in France, he's able to place in the partner country, in this case Switzerland, without any changes to the products or without the need to comply with any different or additional requirements as compared to those with which it has to comply in order to place the product on the market in France or within the EU. With Switzerland, the enhanced MRA came about because Switzerland eventually didn't ratify the accession to the European Economic Area Agreement, which is an agreement between the EU and EFTA countries. And Switzerland is an EFTA country, but nonetheless, it did not ratify the EEA agreement in the 90s. So then, as a fallback option, Switzerland negotiated with the EU a number of bilateral agreements that were aimed at providing some kind of access, smooth access to the EU single market for Switzerland. And in the area of goods, this agreement is the Mutual Recognition Agreement on Conformity Assessment, where Switzerland voluntarily aligns its legislation with the EU and follows the EU approach, and thereby providing the MRA provides for a smoother market access to the EU market for Swiss products and vice versa to the Swiss markets for all the products that are in the scope of the MRA and that come from the EU. So this was only possible because there is a full regulatory alignment on the part of Switzerland. Another type of an enhanced MRA is the MRA that the EU has concluded with the United States and relates to the marine equipment sector. So this in the EU we have a directive on marine equipment, which transposes the international regulations of marine equipment. And in the US, the same is done. So therefore, since both the EU and the US aligned their legislation with international regulations, the possibility was opened to conclude an agreement where the certificates, once issued for a marine equipment product in the EU, are accepted also in the US. So the same product with the same certificate can be placed on the market in the US. And then a third area of an enhanced MRA where the underlying regulations are the international norms relates to the good manufacturing practices for pharmaceuticals. So this is only a part of the process of pharmaceutical products. So I wouldn't like that somebody gets confused that a pharmaceutical that can be placed on the market in Europe or anywhere else in the world can be then placed on the market in Europe without a proper marketing authorization. This is not the case. It's just that the practices, the good manufacturing practices that are used for a pharmaceutical are accepted in the EU and in the partner country market by the authorities when they are evaluating the whole documentation prior to placing the pharmaceutical products on the market. So this is another type of agreements, the enhanced MRAs, and as you can see, there is a very limited use of them so far. There is another possibility for so-called enhanced MRAs, which stems from association agreements with or stabilization and association agreements with the enlargement countries and association agreements with some of the European neighborhood countries, in which agreements there is a possibility to conclude an agreement on conformity assessment and acceptance of industrial products. These agreements would fall into the scope of these enhanced MRAs. However, so far we don't have such agreements except for Israel on good laboratory practices. Oh no, sorry, good manufacturing practices. But it remains to be seen in near future whether we will have similar agreements, these so-called ACAs, with the countries of the neighborhood and enlargement. So here on this slide, you can see what is actually kind of accepted. So it can be a certificates that are issued by the authorities of each party that are accepted mutually. Then it can be certificates by the authorities, but which are based on some kind of test reports that have been done by private conformity assessment bodies. And then it can be the case of tests and certificates that have been issued by private conformity assessment bodies that are accepted by the authorities of the other country. On this slide, you can see the list of all the MRAs or agreements that provide for facilitated conformity assessment acceptance for the facilitated acceptance of conformity assessment results that the EU has concluded. These are links. I believe that you will be able to receive this presentation, so then you will be able to click on the link and access the legal text of the agreement in case you are interested to in the terms of the agreements themselves. Okay, on this slide you can see the sector. So now there will be a couple of slides which with each MRA where you will see the sectors that are covered by the MRA. So as you can see here, there are almost 20 sectors that are covered by this agreement. There is a medical devices chapter that is not in operation anymore. Because it was not updated in a timely manner following the Swiss falling out of the negotiations for an institutional framework agreement. But all the other chapters are still in operation, which means that all your products, if they fall into any of these categories, they can be placed in Switzerland on the Swiss market with the same EU certificate that they have. So it's machinery, personal protective equipment, toys, gas appliances, motor vehicles, construction products, etc., etc., radio and telecom equipment. And I mentioned now lastly the radio telecom equipment because this is a sector which is covered by all of our MRAs and where there is great opportunity to take advantage of the MRAs. And the sector is very relevant because all computers, all connected products are actually in the scope of the radio equipment sector. So in case you need to test your product or certify your product to any of these MRA trading partners, which you see listed here, you will be able to benefit and have your products tested and certified in Europe. Then next in line, comprehensive MRA is the agreement that the EU has concluded with Canada. The original MRA has been taken up within the negotiations of the CETA agreement in the form of a protocol on conformity assessment. The protocol on conformity assessment has two parts. One in which it lists all the product sectors that are in the scope of the agreement and that already apply. And then it has another annex which lists product sectors for which the countries have, the trading partners, the EU and Canada, have agreed to see as priority sectors for inclusion of the protocol. For the time being, and this is on this other slide, so I will come back to that later. On this first slide, you see all these sectors that are covered by the protocol. So nonetheless, even though all these sectors are covered by the protocol in the operation, so really operational, we have only three sectors: radio equipment, ATEX, and electromagnetic compatibility. And indeed, thank you, Maxim, for the question with regard to the sectors. So I received the question from Maxim whether there is a definition of the sector that is covered by the MRA. And I have to say that one a short answer would be no, but a long answer would be yes, because there is a list of legislation to which the MRA apply. So these here, the sectors that I have named on the slides, is only to give you like a broad idea of sector covers. The specificities of the definition of what falls in this broad category of the sector is given by the agreement itself, because the agreement makes reference to the legislation of the parties. So the currently operational sectors are the three that are in a greener, let's say, color here on the slide. So we see that there is a lot of opportunity for EU businesses to take advantage of this protocol, but also on the other side, from the Canadian side as well, and to use it for other sectors. So far, there are no conformity assessment bodies that are designated under these other sectors. So I guess for the manufacturers, it would be difficult well, it's currently for the manufacturers, it's not possible to use the protocol because there are no conformity assessment bodies that are designated. So this is a call from our side to CABs to look into the protocol and to see whether they are interested to become accredited under and designated under the CETA protocol. This is an outreach from our side. We have done some webinars in the context of the 5 years, last year in the context of 5 years of application of CETA. We are continuing to talk to the European Cooperation for Accreditation, or to also chairs of the conformity assessment bodies groups that are established under EU harmonization legislation, to raise awareness of these opportunities and to have conformity assessment bodies designated, because then this will allow manufacturers to use the bodies and their expertise and to receive certificates in these areas. And then there is also a protocol to CETA, which is here on the right-hand side of the slide. It's a protocol on pharmaceutical GMP inspections. So it's part of the CETA. It's not part of the protocol on conformity assessment, but it does allow for the recognition of GMP inspection reports by the EU and Canada. I saw quickly the question with
yes.
regard to, but I was not able to fully read it. So Agnieszka,
Should I read it? Yeah.
Yes, please.
To the sectors that are not fully implemented depend on the CETA full ratification by all member states to be included and applied, or is there no relationship between the two? Just to
Yes, just to be sure, indeed, there is no relationship between the two. The CETA applies provisionally because the CETA, the trade part of the CETA, is the EU exclusive competence, so it does not depend on the ratification of the CETA by all the member states, and therefore, since we already have the provisional application, we can apply the protocol on conformity assessment. So no relationship between ratification and application of sectors. Thank you. And then here the sectors that are envisaged to be included in the protocol, but that have not been included yet. On top of that, there can be any other sector on which the parties could decide to accept certificates. For the time being, the parties are discussing. They are having some. They are not discussing actually the inclusion, but they are having some initial exchange on the interest to include cybersecurity certification in the protocol. But there are also some other discussions whether that could be a self-standing instrument. So, but this is just to mention that that other sectors could be added. In the CETA protocol, there is a provision allowing for that as well. As you can see, the scope is very broad, but we are still to look and we are still to fully benefit from all the opportunities that are provided here. Then there is the Australia and New Zealand MRA. They are basically mirroring each other, also because there is an MRA between Australia and New Zealand where they accept products among themselves. So here, these that are very light machinery, pressure equipment, and automotive, they are not, they don't seem to be operational or used. But there are these others: electromagnetic compatibility, low voltage, medical devices, radio equipment, and medicinal GMPs that are used. There are bodies that from the EU that are designated under the agreement, which means that that European exporters can make use of them. The MRA with the US covers telecommunication equipment, electromagnetic compatibility, pharmaceutical good manufacturing practices. And then although the agreement covers also these three other sectors: electrical safety, recreational craft, and medical devices, they are not in operation because the authorities or the regulators from the EU and the US could not find sufficient trust in order to make these sectors operational. There is a renewed interest in this MRA, and there might be some breakthrough, but it remains to be seen now also with the election what will happen. Thank you, Agnieszka. Yes.
Okay, there is one more question. As far as I know, CE marking regulations allow self-certification for CE marking, or am I wrong? How MRAs deal with self-certification?
Yeah, indeed. In the EU, we have CE marking, which is a marking that shows to the authorities that the product complies with the EU requirements. I think it's important to note that these are EU requirements and that the EU allows for self-certification. I think I have mentioned it at the beginning that in most cases in the EU, or in many cases, or to say, the EU allows for self-certification. So in areas where we allow self-certification, you might be questioning what is the added value of the MRA, but this is actually where we do see added value of these MRAs that the EU has concluded. In particular, you see low voltage equipment, electromagnetic compatibility, radio equipment as well. For most part, it's self-certification in the EU. However, it is not self-certification in the US, in Australia, or New Zealand, or in Canada, meaning that the European manufacturers, in order to export these products to these trading partners, they will have to certify them, and they will be able to use conformity assessment bodies that have been designated under the MRA, under these MRAs. So there is an added value of the MRAs, even in cases, or even more so when the EU uses self-certification. On the other hand, it means that there will need to be some certification, unlike in the EU. But this is a problem. I mean, this is the problem that we cannot address because we cannot force our trading partners to use self-certification. Although we do promote self-certification in our FTA negotiations. So wherever we negotiate FTA, we ask the trading partners to look into possibility to allow self-certification when regulating products that are low to medium risk. With Japan, we also have, yes, there is another question.
Excuse me if the question is not at the right level, but my question is, who pays for the work of the certifying bodies? What are the costs for the company that wants to certify?
Indeed, the cost is borne by the company that is interested to export. This is part of the compliance cost that the company must bear. The same would be to place a medical device on the market in the EU. If it falls into the third or fourth category of medical device, the product will need to be assessed by a notified body, and this is the cost that the manufacturer would need to bear.
And what are the amounts more or less? Is it possible to give the ranges, or
it is very difficult to give the ranges because it really depends on each product, on the complexity of the product, on the number of units that the manufacturer or intends to, or the supplier intends to sell. So there are many, the whether he is dealing with the whether he has already an established relationship with that notified body, with that certifier, or it has a long-term relationship. I mean, I'm not able to give any range because it is really product specific.
And country specific, definitely.
And country specific as well, yes.
Thank you.
So these are the list of sectors that are covered by the Japan MRA, and then with Israel, as I mentioned, there is an MRA on good laboratory practices and an agreement on conformity assessment and acceptance of good manufacturing practices for pharmaceuticals or for medicinal products. I also mentioned already the marine equipment MRA with the US, which is based on equivalence stemming from the fact that both economies have adopted international rules. Now, I think I have only like 4 minutes to go. So what I will try to do, I would like to show you for manufacturers the use where they can find the list of all these conformity assessment bodies. I don't know. I'm probably still sharing the presentation.
Yes, you are still sharing the presentation.
Yes, so I have to see how do I stop sharing the presentation. Yes, and now I start sharing my other screen, which is the
Yes, we can see
access to markets database. So you might be familiar with it or not, but if you type access to markets in Google, it will bring you to the main page of this database, and then you can go to my trade assistant, or maybe you can type that as well in Google. And once you are there, you can put here the product code or the name of your product, the country from which you are exporting your product, and the country in which you are exporting your product. And you put it into search, and the search will list you here a number of products that fall into that category. Then you select one, and once you select it, you will be brought to this page where you have a lot of information about where you can find a lot of information about the requirements in the third country, in this case in the US, with regard to that product. So you see you have also tariffs, you have taxes, you have trade barriers, trade flow statistics, and you have procedures and formalities. For the time being, you also have this box, access to conformity, which you click and it will lead you to the list of conformity assessment bodies. But this will disappear in future, and you will need to go to procedures and formalities, and there you will need to choose specific procedures where you see there is a lot of information about the product requirements. You see on general, the commercial invoicing, the packaging list, the importer security filing. But for specific, the first one is access to conformity. And once you click there, you will have the information about the mutual recognition agreement and the list of conformity assessment bodies in all European member states, which you can use to certify these products for the US. Similarly to this, you can find for other MRA partners that I have listed in the presentation. You can also go and check the list of conformity assessment bodies on the website of DG Grow, where there is information about the MRAs, but there is also a list of notified bodies that perform conformity assessment here. It is a lot of clicks, a lot of repetitive information, but if you look through the countries here, you will be able to find the bodies. So I will stop sharing this now, and I will go back to my presentation because I just want to make a brief. Something happened with my.
Katja, can we do a comparison that the MRAs for international trade are something similar or the same that CE marking for trade within the EU, following the Marcos question?
I think it would be. It wouldn't. It wouldn't really. It wouldn't be correct to make that comparison. What do you see now? Because I think I have a problem. Okay.
Nothing for the moment.
Nothing for the moment. Okay, because I had some. It seems as if I cannot share. Yeah. Okay.
Katja, will 5 minutes more be enough?
Yes, 5 minutes, it will be more than enough. It's just my last slide where I wanted to mention that that when there is no MRA, there are still, as I mentioned, we are advocating the use of suppliers declaration of conformity through our free trade agreements with a varying level of success. However, there are also cases where the countries unilaterally accept our certificate. So you will have, and I think this is Agnieszka, maybe a part of the answer to your question. In some economies, some developing countries who do not have capacity to make their own legislation, they will use our legislation, and they will unilaterally accept whatever is in the EU. So whatever is compliant with EU requirements is automatically accepted in that country. So they will accept the supplier's declaration of conformity and the CE marking, and they have legislation in that country which unilaterally accepts EU legislation. And then there are schemes that are international schemes for acceptance of certificates and test results, in particular in the area of electrical products. The scheme by the International Electrotechnical Committee, the so-called ISECB scheme, which provides for a mutual acceptance of certificates issued by bodies that conformity assessment body or certifications and laboratories that are participating in these schemes. There is also the acceptance of test reports or certificates issued by laboratories or conformity assessment bodies that have been accredited by ILAC and IIF, which are the International Laboratory Accreditation Scheme. Since in the EU, the European accreditation bodies are members of ILAC and IIF, this means that the bodies, the conformity assessment bodies that they accredit, are automatically also accepted as accredited by ILAC and IIF, meaning this means also then, as a result, that European conformity assessment bodies are able to issue test reports and certificates that can then be accepted abroad on the basis of this ILAC and IIF accreditation. And the last but not least, the regulatory dialogues that the EU carries with the many with many trading partners, in which the EU promotes more the supplier's declaration of conformity in a similar way as we do in FTAs. So this would be to conclude. This is my last slide. I'm open to your questions now, and I will stop sharing the screen.
I think that we followed the questions in the meantime of the presentation, and there are no more questions. At least I cannot see any. And the time is more or less over. So I think that I can say thank you very much, Katja, for this informative and very interesting presentation. And I think all the participants now have the idea what the mutual recognition agreements are and what is the added value for companies by being aware of them and being aware how to use them for international cooperation benefits. Today, thanks to you, Katja, we dove deep into the mutual recognition agreements and their pivotal role in facilitating market access for European small and medium-sized companies and startups. We found out how the mutual running agreements serve as essential tool in reducing the costs and time associated with the mandatory certification and testing of products, ultimately making trade quicker, easier, and definitely more cost-effective, but not compromising on safety. In concluding today's event, I would also like to remind that Enterprise Europe Network, besides the webinars like the one of today's organized within the initiative Embracing Global Markets mentioned by Eric in the opening, provides a broad range of services to support and foster the internationalization of European small and medium-sized enterprises. Just to name a few: organization of dedicated sectoral international company missions and brokerage events, support to benefit from access to market database, which was presented by Katja, and also the use of free trade agreements, preparation and worldwide promotion of companies' profiles regarding products, services, or technologies, leading to the signature of international cooperation agreements, and also a wide range of advisory services. To tell about just a few: the technology audits, design audits, legal and patent attorneys advice, certification and standardization advice, and many, many others, which foster the potential for, cooperation, international cooperation of small and medium-sized enterprises. And just to finally conclude, thank you very much, Katja, Eric, and all of you for making this webinar a success. And let's keep the conversation on mutual recognition agreement, on free trade agreements, towards a more accessible and prosperous future of European businesses in the international market. Thank you very, very much. I don't see any more questions, so I think, or any more conclusions.
Thank you.
We are done. Thank you very much. We can stop the recording, and all the recording and the presentation will be available on the Learn platform, and also the recording will be available on YouTube. So you can come back to this and learn more about the mutual recognition agreements. Thank you so much.
Thank you very much.
Thank you very much.
Thank you. Bye-bye all.
Bye-bye. Thanks.